When Bill Clinton walked into courtroom 9C with nothing but a battered briefcase and a worn-out notebook, the entire room scoffed. A former U.S. president defending himself in a multi-billion-dollar pharmaceutical scandal without legal representation seemed not just arrogant but insane. But behind Clinton's calm gaze was a carefully laid trap, a plan so intricate, so quietly devastating, that by the time the gavel struck for final judgment, the courtroom wouldn't just be stunned. They'd be reeling. This wasn't just a trial. This was a masterclass in legal strategy. Federal District Courtroom 9C buzzed with quiet anticipation. A hush fell as the courtroom door creaked open, and former President Bill Clinton entered, flanked by no one. No lawyers, no aides, no security detail. Just Clinton in a navy blue blazer and slacks, carrying a coffee-stained legal pad under one arm. Judge Samantha Halbridge glanced over her glasses, barely concealing her disbelief. "Mr. Clinton," she said dryly, "you are representing yourself today." "Yes, Your Honor," Clinton replied, his southern drawl calm and disarming. "I figured this matter was important enough to handle personally." The courtroom murmured. One of the junior clerks leaned to another and whispered, "This is insane." Opposite Clinton sat the polished legal team from GenCure, one of the largest pharmaceutical giants in the world. Lead counsel Leonard Strass stood, his $4,000 suit immaculately pressed. He smirked as he addressed the judge. "Your Honor, GenCure intends to prove that Mr. Clinton's foundation unlawfully obtained and distributed a patented cancer treatment formula developed exclusively by our client. We intend to show theft of intellectual property on a massive scale." Judge Halbridge nodded. "Thank you, Mr. Strass. Mr. Clinton, your opening statement." Clinton stood, walked slowly to the center of the courtroom, and began. "I've never stolen anything in my life," he said, voice low but firm. "Least of all medicine meant to save lives. What GenCure calls theft, I call humanity. And by the end of this trial, I think you'll see the difference." Strass chuckled, arms crossed. Emotional appeal. Classic Clinton. But the judge raised an eyebrow. "Mr. Clinton, do you have evidence to present?" "Soon," Clinton said. "But first, I'd like to hear exactly what they're accusing me of." Over the next hour, GenCure's attorneys unloaded mountains of documents, lab reports, patent filings, and corporate charts. Their argument was clean, rehearsed, and, on the surface, damning. "We have direct proof," Strass said, "that the Clinton Global Health Foundation used GenCure's patented genetic structure for a chemotherapy variant and distributed it to clinics in West Africa without approval or a license. That is theft, Your Honor." Judge Halbridge nodded and turned to Clinton. "Do you dispute this?" Clinton didn't flinch. "I dispute their version of events." Throughout the testimony, Clinton jotted silent notes, occasionally glancing at the bench as if half listening. But in truth, he was listening to everything. Every word, every phrase. And with every line GenCure's attorneys delivered, a quiet, unseen thread was being spun. One that would tighten, sharply soon. From the gallery, a woman with curly gray hair watched Clinton carefully. Dr. Evelyn Morse, Clinton's longtime advisor and molecular biochemist, clutched a small USB drive in her purse, fingers white with tension. They had rehearsed nothing. Clinton insisted that surprise was their ally. But as the evidence mounted, her confidence wavered. "I know what I'm doing," he had told her just hours before the hearing. Now, watching the courtroom laugh quietly at her former boss's amateur lawyering, she wasn't so sure. But Bill Clinton? He had never been more certain of anything in his life. He wasn't here to play defense. He was here to blow the case apart, one move at a time. Court resumed the next morning with an undercurrent of anticipation. Judge Halbridge adjusted her glasses and called the session to order. GenCure's legal team sat upright and confident. Clinton, once again alone, calmly flipped open his notebook. "Mr. Clinton," the judge said, "you may now begin your cross-examination of the witness from GenCure." Leonard Strass's lead witness, Dr. Valerie Lynn, had just completed her explanation of how GenCure had developed its cancer-fighting compound over 7 years of isolated research. According to her, there was no way the Clinton Foundation could have accessed the patented compound's full genome sequence without illicit means. Clinton rose slowly. Dr. Lin, he began, could you confirm the date your team started development on this treatment? She adjusted her collar. March of 2018. Clinton nodded, and the patent was filed. February 2022. And between those years, GenCure hosted 2 open-source symposiums, correct? Events where you shared preliminary findings with select partners. Strass stood immediately. Objection. Irrelevant. Overruled, said Judge Halbridge, curious now. Dr. Lin hesitated. Yes, but we never disclosed proprietary formulations. You did, however, Clinton continued, distribute early white papers, didn't you? Especially to African health NGOs. Lin's lips parted slightly. We did share limited research for humanitarian feedback. Clinton stepped closer to the jury box. So, it is possible, in theory, that multiple labs around the world could have contributed to that same line of research. Strass interjected. None of them produced what we did. Sure, Clinton said. But let's talk about what you didn't produce. The room leaned in. You didn't produce the emails your VP of Outreach sent to our foundation in 2019, inviting collaboration on genetic replication trials in Liberia. You didn't produce the joint statement your legal department signed during the Lagos Summit in 2020. Strass's face tensed. Dr. Lin looked alarmed. Those emails and agreements, Clinton added, are in this folder. He placed a thick envelope on the defense table, and they paint a very different picture. Judge Halbridge raised a brow. You intend to submit those today, Mr. Clinton? Yes, Your Honor. Strass stood again. Your Honor, we've never seen these documents. We challenge their authenticity. I assumed you'd say that, Clinton replied. That's why I asked 3 independent forensic analysts to verify the email headers and server routes. I have signed certifications from all 3. The gallery murmured. Even the stenographer paused for a moment to glance at the defense table. Judge Halbridge flipped through the papers handed to her by the clerk. Interesting, she muttered. These show that GenCure not only collaborated with the Clinton Foundation in early-stage testing, but that they proposed the idea themselves. Strass whispered furiously to a junior associate. Clinton stood motionless, hands folded, and then the trap snapped tighter. With the court's permission, he said, I'd like to play a recording. Of what? Halbridge asked. A phone call, Clinton said. One placed to Dr. Lin's office by a GenCure executive 3 days before the trial began. Strass bolted up. Objection. That was illegally obtained. Clinton shook his head. Not at all. My foundation's calls are automatically recorded for compliance reasons. This one came to our lines. I just asked Dr. Lin to confirm her voice. All eyes turned to her. She looked like she wanted to vanish into her chair. Judge Halbridge leaned forward. Play the recording. A few seconds later, the courtroom filled with a man's voice. If the Clintons dig into the Lagos agreements, we're in trouble. Say the documents were fabricated or misinterpreted. Make sure Lin sticks to the official narrative. Strass's face went white. Clinton walked back to his seat without a word. Not a smile. Not a glance. Just the slow confidence of someone who knew that everything had just changed. Judge Halbridge called for a recess. Outside, reporters were already tweeting. Clinton drops bombshell email evidence. GenCure CEO's secret call exposed in court. Back in the gallery, Dr. Evelyn Morse finally exhaled for the first time all morning. She wasn't worried anymore. The game had shifted, and Clinton was now in complete control. The courtroom buzzed with whispered conversations as Judge Halbridge re-entered and called the court back to order. The mood had shifted. The confident smirks from GenCure's team were gone. Leonard Strass sat stiffly, hands clenched on the table. Clinton, by contrast, looked almost serene. Mr. Clinton, the judge said, you may proceed with your presentation of evidence. Clinton stood and walked to the center of the room, a file in one hand, a small digital projector in the other. Ladies and gentlemen of the court, he began. What you're about to see isn't just proof. It's a map, a timeline, of how the Clinton Foundation collaborated with GenCure on what was once a shared dream, and how that dream turned into a corporate betrayal. With the click of a remote, a holographic timeline appeared over the courtroom floor. Events pulsed in bright sequence. 2019, Jen Cure contacts the Clinton Foundation to explore joint research on nanoadaptive gene therapies. 2020, Lagos Summit MOU signed. 2021, field trials conducted jointly in Liberia. 2022, Jen Cure files independent patent without disclosure. Whispers echoed through the gallery. The judge leaned in. Each point here, Clinton said, is backed by signed documents, email threads, and in-field photographs, all time-stamped, geotagged, and independently verified. He turned to the judge. Your Honor, with permission, I'd like to enter these into the record. So entered, she replied, not even waiting for Strass to object. Clinton pressed another button. A live feed switched to a secure Zoom call on the projector screen. A woman appeared, mid-30s, clear-eyed, her nameplate reading Dr. Amara Yude, a Nigerian biochemist formerly employed by Jen Cure Africa. Dr. Yude, Clinton said, can you tell the court where you are right now? I'm in Lagos, she replied, outside jurisdiction, but willing to testify remotely. And why did you leave Jen Cure? Her voice didn't tremble. Because I realized we were asked to erase records. My team's name was scrubbed from published results. The company was preparing to claim sole credit for a project built by two. Gasps again. The jury looked stunned. Strass stood. Objection. Remote testimony like this is legal under international agreement in fraud investigations. Clinton cut in, especially when the witness is in protective custody. Protective custody. Judge Halbridge glanced down at her notes. Continue, Mr. Clinton. Dr. Yude continued. Jen Cure's executives, under Leonard Strass's directive, ordered all digital evidence of partnership with the Clinton Foundation deleted. Some employees refused. They were terminated. Do you have evidence of these orders? Yes. Yude lifted her phone and read out a memo. Project Liberty Partnership must be deniable. Clean all metadata by Thursday. Do not leave loose ends. It was signed by Strass's chief of staff. Clinton nodded. Thank you, Doctor. That's all. He ended the call, leaving the room silent once more. Then he said calmly, the defense rests its case, but I suggest the prosecution reconsider theirs. Judge Halbridge cleared her throat. Mr. Strass, do you wish to respond? Strass rose, but for once had nothing to say. His gaze flicked to Clinton, then to the judge, then down. Outside, news alerts exploded across the web. International whistleblower confirms Jen Cure fraud. Bill Clinton's legal gambit pays off. Strass cornered by former allies. And in the back of the courtroom, a man in a dark suit with a Department of Justice pin quietly exited, phone to ear. He had heard enough. Bill Clinton returned to his seat, calm as ever, while Leonard Strass stared ahead blankly, his team frozen around him. It wasn't just that their strategy had failed. It was the manner of their defeat. Public, methodical, and impossible to refute. Judge Halbridge turned to Strass. Mr. Strass, I assume you will be calling witnesses for rebuttal? Strass stood slowly. Your Honor, Jen Cure will not be presenting additional witnesses at this time. Silence. The judge tilted her head. You're resting your case. Yes, Strass said quietly. A ripple passed through the courtroom. The defense had called no one. They had folded without a fight. Clinton didn't smile. He simply opened his notebook and jotted something down, as if tallying an invisible score. The judge nodded. Very well. Mr. Clinton, you may proceed with closing arguments. Clinton rose, walked to the center of the room, and looked directly at the jury. 3 years ago, he began, this courtroom wouldn't have believed that a former president would stand here alone against one of the most powerful biotech corporations in the world. But justice doesn't rely on numbers. It relies on truth. He paused, letting the silence settle. The evidence you've seen paints a clear picture. Jen Cure did not invent Project Liberty. They hijacked it, erased the names of those who built it, and replaced them with their own. Their own documents prove it. Their former employees confirm it. Their silence today only confirms it further. He stepped closer. This case isn't just about biotech. It's about power, accountability, and the cost of forgetting who we're supposed to serve. I stood here, unarmed but informed, alone but not unprepared, because some truths are too big to hide, and because some battles still need to be fought in person. He bowed slightly. I rest my case. The courtroom sat frozen. Even the stenographer had stopped typing, her mouth slightly open. Judge Halbridge cleared her throat, clearly moved. We'll reconvene tomorrow at 10 a.m. for final judgment. As she struck her gavel, the cameras in the hallway outside were already rolling. Clinton stepped out to a wall of reporters. Mr. Clinton, are you confident about tomorrow's verdict? He smiled slightly. I'm confident the truth has been heard. Back in the courtroom, Leonard Strass sat motionless. His lead attorney leaned over. We may need to negotiate. If this verdict goes against us, the SEC and DOJ will come knocking. Fast. Strass didn't respond. His empire had just been publicly dismantled, and Bill Clinton hadn't even broken a sweat. Judge Halbridge entered the courtroom at the crack of dawn, her robe sweeping behind her like a banner of authority. Every seat was filled. Tension crackled like static in the air. Bill Clinton sat calmly at the plaintiff's table, his notebook open and ready, eyes steady and confident. Across from him, Jenkire's team, Leonard Strass and Damon Reeves, looked increasingly like hunted animals. The judge's gavel sounded once. Court is now in session, she announced. This is the matter of Clinton Innovations versus Jenkire, regarding Project Liberty. Her gaze surveyed the packed room before settling on Clinton. I have reviewed the evidence, witness testimony, internal memos, emails, security footage, and staff notebooks. A hush fell. Strass shifted uncomfortably in his seat, his veneer cracking under scrutiny. Silence reigned as Judge Halbridge continued. Dr. Amara Ute's testimony, the photos of Jenkire's staff taking unauthorized pictures in Clinton's secured lab, and Mr. Strass's own entry. Fast-track our version before he patents it. Establish deliberate corporate espionage. She paused, letting the words land like stones. Clinton nodded almost imperceptibly, reaffirming his prior belief in justice and thorough preparation. The judge's tone hardened. This court finds Jenkire guilty of corporate espionage and patent infringement. Patent hashtag 372041 is revoked effective immediately. Gasps rose from gallery. Reporters leaned forward, pens poised over notebooks. Clinton's face remained composed, but the satisfaction in his steady gaze was unmistakable. Furthermore, under Section 47B of the Technology Protection Act, Jenkire is hereby prohibited from developing, producing, or marketing any energy storage technology using the nanoadaptive coating, or any substantially similar variant, for 5 years. Strass's complexion went pale. Reeves' pen stilled mid-note. The courtroom felt the weight of that 5-year sentence. The judge tapped her gavel lightly. Additionally, Jenkire shall pay Clinton Innovations $50 million in damages, restitution for stolen IP, lost market opportunity, and legal costs. Finally, the court refers this case to federal prosecutors to investigate potential criminal charges, industrial espionage, document tampering, and perjury. Silence met Judge Halbert's conclusion. Clinton rose when addressed. His measured voice carried through the hush. Thank you, Your Honor. This verdict upholds the integrity of innovation. It sends a message. Shortcuts and theft carry consequences. We rely on intellectual honesty to drive progress. I hope this ruling discourages others from stealing, because genuine innovation must be earned, not stolen. The judge nodded once, sharply. Court is adjourned. Her gavel fell, sealing the verdict. 2 months later, at Jenkire's headquarters, an atmosphere of hushed chaos reigned. Strass, pale and defeated, left a private board meeting flanked by reporters. He announced his immediate resignation. I'm stepping down. Jenkire will comply with the court order and rebuild under new leadership. An unspoken tension followed him as Reeves trailed behind, visibly rattled. The scandal damaged their reputation. 5 years sidelined from a key market, and criminal charges looming. Their future in flux, the company scrambled for a pivot. Meanwhile, at Clinton Innovations, the mood was one of cautious triumph. In the lab suite, engineers and developers tapped away at prototypes, new battery models, hydrogen cells, climate tech projects. Clinton walked among them with purpose, his face reflecting pride and determination. "Let's get back to building," he said. "There's plenty of work left to do." His words felt like a starting pistol for a new race, driven by integrity. Judge Halbridge, back in her chambers, carefully reviewed her final ruling. 30 years on the bench had equipped her to detect deception and truth. She kept a photo on her desk, her younger self in an MIT lab with a battery prototype, her face alight with ambition. She remembered why she cared about protecting innovation. The case had reminded her that justice wasn't just a formality. It had a role in shaping the future she had once helped build. Clinton's legal victory wasn't just a win for one company. It set a precedent. Corporate espionage could no longer be shrugged off as a cost of business. It mattered. The full consequences, patent revocation, a 5-year development ban, criminal referrals, underscored that seriousness. And for Clinton, it marked a turning point. From courtroom strategist to industry defender, he had protected not just his ideas, but the ethos of invention itself. If you liked the video, don't forget to subscribe and press the like button.